we have started this program now. So this session will continue, and then when Honorable CM or his representative comes, then we will start the formal inauguration. So that the entire issue is jam-packed. So we need not to lose any time. We have taken up this step. So I hope all of you understand and appreciate. Thank you.
Sir, may I request you to take over? Thank you so much. Thank you. Sir,
yeah, good morning, everybody. Thank you, Amurji. So, see the panel. We have 4 eminent members, 3 members, the chairman, and we have an hour or so. So, as discussed with all the members, we will have 10 minutes each, starting with Professor Nari, and then Professor Rao will make his remarks, followed by Chairperson Andhra Pradesh. We will make a presentation of around 10 to 15 minutes later on, and the last 15-20 minutes will be open for the discussion. So the presentation in on a case of the Bihar Public Service Commission regarding the 78th Combined Civil Services Examination, which went right up to Honorable Supreme Court, and which may have some interesting issues decided at High Court level and then at the Supreme Court level also, which will be of interest for all of you, may be relevant for all of you. This case was discussed in the national conference very briefly, and again in Tamil Nadu also informally. And many of the members were of the opinion that a formal presentation should be made on this. So we took this opportunity, and we'll try and squeeze in whatever we wanted to say about this case, around 10-15 slides. So we'll start with Professor Nari's comment about this session, and then we'll take it forward. We'll try and complete it within 1 hour. Thank you.
Good morning, one and all. Honorable chairmen from the different PSCs, members, secretaries, and other staff of all other public service commissions. Welcome you all on the behalf of TGPSC. And because of its important of the topic, our chairman has initiated the whole commission, what we are facing day-to-day activities and the litigations. So let us have the discussion among all of us and support each other to bail out the issues. Well, and also I thank all the organizers for giving me opportunity to share some of my experiences. Though, of course, I am not the domain of the legal, but I am slightly associated with the activities that is towards the recruitment process. Just I'll share some of the, let's see, okay, it is like swimming in sea, and let's see how we can reach to shore. Well, as we know that the nature of litigations in public service commissions very wide. It's very difficult to count, but however, just to with some extent made into 6 broad type of the litigation that we come across. Mostly, like, of course, they are not limited to this. Mostly we will come across the litigation on notifications, and that's the reason we feel its notification is very important, that document. And then examination procedures, which is really, it is not visible to any of the stakeholders, but you'll find a lot of litigations in the examination procedures, government GOs and its amendments, rule of reservations, and local and non-local issues, mandatory instructions to the candidates, and whatever we communicate to this, all the public, that also is made into as a litigations, and also the commission's autonomy, that also is a question is now and then. Let's see, like, briefly, just I'll cite some of the examples. I don't like to give a theory on this. Just we'll quote some of the case studies, what kind of the litigation we have faced, and what are the landmark judgments on each of the issue. First, just let me take the examination procedures. This is really either neither candidates, not general public, not aware of what exactly takes place in the background of the examination. Broadly, it is a three-stage process: before conduct of exam, during the examination, and post-examination process of it. Okay, so the before the pre-examination, generally we make all the arrangements and planning for conduct of examination. It's wide open. Okay, even that some of the participants are the stakeholders are raising the litigations of it. It's why this test center, how to generate the all tickets. Even though it is a regular routine process, even that it is the litigations have been raised. And broadly we have the examination pattern is two kinds: is a multiple choice questions and descriptive type. So when we make the question paper, either is MCQs or the conventional or descriptive type. So it is rely on the experts, and the in charge of who is the examination process, the control of examiner or confidential member or the chairman. So we have to trust with the experts. The experts are really, the quality of the experts is essentially outcome of the quality of the examination. But really, we need to say how best we can track. That's we'll get the best possible one. But now, when it comes to resources, the resources are abundant. It's not limited. And one of the limitations, the resources are not validated anytime. See, it is wide open to all the resource persons to provide the information, but it is not validated or standardized. We take is the experts, whatever is accessible to the resource, he will prepare or generate or create the questions, and then provide the answers to the keys to that. So we commissions would depend on that. So there may be maybe the different source may be available contrary to that, or maybe that resulted maybe is a wrong answer, that may result is a multiple answers. And sometimes, when the process of preparing the question paper or there may be typographical mistakes of it. Okay, so these are all is some of the gaps where we'll face the litigations of it. But anyway, so all the time, so it is the point where we need to all minute to minute we have to highlight, and in spite of that we'll get, but no other way. To the possible, when you are recruiting the commission level, so we expect the result should be, the candidate should be selected is the analytical nature and best possible one. So just for sake of selecting, we cannot give straight away questions or So we bound to face the litigations, but we need to know the trade of how best we can formulate this. Okay, the one of the the case WP recently. Okay, there are number of cases there. Recently on the Group 1 of Telangana Public Service Commission preliminary exams, there are a number of objections raised in spite of the very rigorous activity. Of course, the judgment has come in, like, no, the rule out the based on the justification provided for each and one and of. And well, the one of the classical case, like, no, recruitment of junior panchayat secretary. Incidentally, I was the convener for conduct of examination. We don't expect the, like, no, litigation of this kind. The eligibility is a graduation. The candidates expected to test in English language, and in English is one of the part is the comprehension of it. Okay. So no one can expect that, okay, we need to translate it the regional language, right? So we, as a pattern of conduct of exam, it was given is the same as a comprehension. So all of a sudden is litigation has come. We are the regional language medium, so it is not translated. And it has gone to the months together. Finally, we need to convince and then appeal, but still it has gone to the appeal. Finally it has the constituted committee, and then outcome of the committee is the final. So what I'm trying to say here is, like, though it is obvious, and then even then it's a litigation has been is raised. Of course, is a descriptive type of examination. We need to look at the scope of questions, evaluation process. These process we cannot list, make it public. Why? Because it's more you give it, you have to face more challenges of it. Like, generally it is not supposed to be make it as a public. And then, though even in a notification we keep mention, like, revaluation is not there, will not be entered. Still, we make a litigation. I think there is in the Supreme Court. Okay, there are number of WPs and civil appeals. Pramod Kumar Srivastava and Vikesh Raj Gupta. In the number of the cases, it is ruled that, okay, revaluation is not. In absence of any provision of revaluation of answers books in the relevant notes, no candidate of examination got a right to whatever is a claim or ask for revaluation of his marks. So this is a thumb rule, right? Okay. So only thing is we need to, without mention in the notification, revaluation is not there. So we can avoid this litigation of it. And notification, of course, notification is very wide, lengthy document. But no, there are certain points, like still we face, like, equivalence of certificate or experience certificate. Especially experience certificate is really, it will be given by the different departments, are like, it may not be standard. We cannot expect the standard from the different departments. So the equivalence of certificate, like, one of the just classical example, post required is the qualification is economics and commerce and mathematics. But a petitioner is like with the BTech qualification, he contented for the post for accounts officer, like. So the tribunal of APS, like, the given concession, but permitted, but bench has set aside the court. The another is, like, pertaining to eligibility criteria post of principal. Petition do not have eligibility criteria notify employers, but so in this also is when they rejecting the candidate of petitioner. So this has ruled out the eligibility criteria of the principal. Age relaxation, like, and there is a request of the 2 years of overage relaxation for the recruitment of AEE, and there was no recruitment. The reason is there was no recruitment for quite some time. Okay, so with that, but it was not considered. The court has not given any relaxation because based on that, the government has not given that. So this is the obvious thing. And another is like suppression of material. It's very, very important. We may feel that sometimes sympathetic towards the candidate. That should have, like, not disclosing the previous appointment of in the application. The cancel, so that boils down to the cancellation, refusal of appointment. Person who indulges suppression or suggestion of falsity does not deserve the public employment. We are being the recruitment agency. We should not be any sympathy. Like if you are sympathetic for one person, we are doing injustice to other. So that we have to go as per the rule. That will avoid some of the litigations of it. Rule of reservation. Yeah. Well, there is a ambiguity or the queries between the vertical and horizontal reservations of it. And they, in TGPSC, we, there was contention on this, in the appointment of junior election. It's not that only this case, but there may be a number of it. I'm just citing one of the example. The PWD category is claiming for the considered the vertical reservation. So but no, specifically, actually in the government GO, it is specifically is not mentioned as a horizontal reservation. But there are the judgments on the in the Supreme Court that the woman and physical person with challenge and any special reservation to be considered as horizontal reservation. Of course, the AP has given the GO pertaining in regarding the so later in TGPC also is given towards this. So the results we have to be very careful whether it's included in the GO or not. Instructions to the candidates. Instructions are instructions published in the notification and other form of it is, it can be considered statutory effect. Whatever we communicate, that's a rule. And one of the classical case of Telangana, Tamil Nadu Public Commission, the candidate has marked answer scripts with pencil. So that has maybe is an indication of some symbolic representation. The Honorable High Court of Tamil Nadu is allowed with writ petition as a made writ petition, but Public Commission of Tamil Nadu has made an appeal, and the Honorable Supreme Court has set aside the judgment of High Court. So this is one of the example the instructions are to be. Yeah, Commission of Autonomy. Okay, so the Supreme Court clarifies that the Public Service Commission's autonomy is recruitment and conduct of examination and interviews only. So this is there are this these judgments, and so this all is I thought of sharing. These are some references. Anyways, for sake of reference, I am just providing some of the judgments of 20 plus. Thank you for your attention. Thank you for giving opinion. Thank you, Vanada.
Chair of this session, Sri Parmar Ravi Garu, Madam Anuradha, friend Yadagiri and friends. The nature of litigation and challenges reflects a human crisis. Justice Krishna here, in a very celebrated Nandini Shatpati case, I think most of you may be aware, he starts the judgment with every litigation is a human crisis. It reflects life's vicissitudes. So that's a one phase of a person comes before the court because of several complexities. Litigation, several causative factors. All of us are responsible for litigation, starting with the law, procedure, complexities, lawyers, judges, and all of us, as Yadagiri has pointed out, starting from the notification till the results declaration. Clarity, simplicity, language, that's. So I think that's where the proactiveness of all the Public Service Commission. I'll begin with that, and I'll go as a law teacher, more than 3 decades, and looking at how do we resolve. That's what 2000 was the first, in fact, more than even 2000. In fact, many people have said when the common law system originated in India, they have dismantled, the Anglo-Saxon legal system has dismantled the existing indigenous dispute resolution. Mark Gallant, you name anybody who has studied Indian litigation. They have also said long ago, before now we thought about 2000 Alternative Dispute Resolution, Arbitration Act 1996, give a history and overview of litigation. How do we address this? I appreciate Telangana Public Service Commission taking this initiative, and I am grateful to you, all of you have come. In fact, one of the purpose of the Nalsar or any NLU is to resolve and promote justice. That's where all these law schools came. The first law school, Bangalore in 1988, and after 10 years, the Nalsar. In fact, when 1998 Nalsar was set up, that was the time high-tech city was coming up. So we named this city Shamirpet as a justice city. In fact, that's not just a tokenism, but our aspiration. What is that aspiration? We wanted to bridges between technology and justice. I think that is what is necessary. So let me just briefly look at litigation, how do we address. One is that 1999, there was an effort made to amend Section 89 CPC. You know, I think major litigator is a government. 46% litigation government. Sometimes our ego, that's all. Sometimes, no, because we said, मेरा पैसा क्या है? Government का पैसा है. If I am an individual, I'll say, हम बात करेंगे, बुलाओ. That's what is. So that's what this 46% litigation is a government. Okay. So 89 CPC. Amazing. Because that's a reflection all over the world. We have to resolve. No conflict. In fact, I tell all my students, we never thought Ayodhya case will be resolved. Look at that. Changing mood, not just in the Supreme Court, sitting people. 3 mediators went to Ayodhya. Entire mood. Nobody wants. So therefore, that's a trend all over the world, including in India, to how do we resolve it. Section 89 is a landmark, 1999, 2000. In fact, that time we organized a discussion like this. And that time mood of the lawyer is, even the court judge is that, nahi, I am losing my money. Mera paisa jayega, mera adjournments jayega. But now it's changed. Lawyers, judges, everybody is learning the skills of mediation, arbitration, and consensual dispute resolution. So 89 marks 2000 to 2025. That's a long journey. Judicial mindset has changed. Lawyers' mindset has changed. Legal academia, we are all also looking at. So that is the first one. Let me look at. I will not go into much details because we will have a discussion. We wanted to hear both Anuradha ji and Ravi Parmar about their case studies. So notification, exam procedure. In fact, we conduct common law admission tests for many years. In fact, that was the first so far, neither JEE, NEET, several times Supreme Court has said, but it's the first time we also realized CLAT. And CLAT, just, I'll just leave, I will not go into much details. Question paper is something which is, we should be very careful, Public Service Commission, please. We avoid even none of the above, we should not give. All of the above we should not give. And there's I know confidentiality. We have been, last 10 years, we have been doing the common law admission test. We know about that. But clarity, question paper, database, simplicity, simple. There's a lot of, we are giving a choice for the court to point out. So that's a question paper, notification and other. So let me come back to the mediation. And another 2 minutes I'll take. So as I said, there's a lot of efforts. 2000 Mediation Act. 2023 Mediation Act not only is now rules have to come up, okay, and rules will come, which is a landmark moment in India's legal landscape because it consolidated different mediation practices under one comprehensive legal framework. They have almost all brought several laws together, and the first thing is it also has promoting technology, online dispute resolution. I think that's going to be, and with the AI, it will really help. But of course, ultimately with the technology, online dispute resolution, artificial intelligence, somebody human mind also has to look at and finalize. Second 2-3 issues is like, we did some studies in Delhi as a part of the Law Commission of India looking at what is the best disposal method. Whether it is a time-based disposal, case-based disposal, and several others, but still benchmarks have not been. It resulted in a report of the Law Commission that was the 245th Law Commission of report. And that was the time we studied Delhi High Court, Delhi Court, civil cases, criminal cases, and still it's not resolved. So that was a case which came from Imtiaz Ahmad versus State of Bihar, where all criminal cases are pending. Nothing we move because interim order by the Supreme Court, High Courts, and complete. So in that context of the Imtiaz Ahmad versus Union of India, they have asked the Law Commission that 245th report, at least interesting. So we need a benchmarks. I'll give an example. Murder trial can be completed within 1 year. Let's say after filing, maybe it's difficult with the new criminal laws. Timelines, at least first time we see in the new criminal laws. Whether we will follow or not follow, that's a different thing. But timelines. Similarly, we need to identify the various issues in the Public Service Commission timelines and other. 2 minutes, Samir has cautioned, so I'll just briefly look at. So benchmarks of what are the routine type of cases. Maybe a national research study would help. That's what always, if we look at abroad, anything which comes for a reform comes through an empirical study which convinces the court. So I think that's maybe the better. There are multiple factors, not just only law, lawyer, judicial mindset, and lawyer mindset, and all of our mindset. We should not point only finger at the court, but all of us are combinedly responsible. There are also multiple factors. Delays can be caused due to challenges of lack of infrastructure, computers. In fact, in our study in Delhi, we found, they said, we don't need judges. What we need are good stenographers. That was what we found out. So there's several factors: lack of infrastructure, lack of support staff, lack of adherence to strict deadlines, continuance of cases, poor quality of counsel, because that's another one. So one, transparent time-bound recruitment process, I think we should be. Data management and modernization, and as far as possible, clarity in everything. I know it's very difficult. So lastly, I am a strong votary of alternate dispute resolution, online dispute resolution, use of all technology. I think I'll once again stop here. We look forward next 2 days, and we all of us, this is a right and opportune time with the Mediation Act, online dispute resolution, technology. Hyderabad is known for technology, and the giant of the technology. We will be happy to work with all of you, and let's see, at least the next 5 to 10 years, there will be at least 5% of reduction of this. I will not promise that 100% we will reduce, but let's make a positive trend towards conflict resolution. That should be the primary decision of all of us. Thank you for giving this opportunity.
Thank you, Professor Rao, for your thought-provoking comments. You have really set the tone for this conference. May I now request Madam Anuradha ji to make her presentation.
Good morning, friends. This session is on challenges for the public service commissions. I think the first and foremost challenge is to complete the recruitment on time. When I joined as chairperson, a close IAS friend, he said this, Madam, I applied for UPSC and APPSC at the same time. I got into IAS, got married, had children, and after that, my appointment as Group 1 officer came through. So that's the fate of most public service commissions. So that is the primary challenge, completing a recruitment within a reasonable time frame so that you don't really mess up the lives of the candidates. The second challenge that we face is standing councils. Now, standing councils for public service commissions are mostly political appointees. And every time a government changes, they're given a subtle, this one, please resign and go. And then the time taken for new appointment, and in the new appointment, we have no say whatsoever. The AG, he will select. So he has to sort of get into this one. The recent government change, I think we did not have a standing council for more than 6 months. And all the cases just were sitting like that. The third challenge is the budget. Many other service commissions may not be facing this, but I think our government at some point of time felt that APPSC is getting too independent. So it removed the head of account, which allows us to pay the legal expenses. So, I mean, the APPSC at that point of time was appointing its own lawyers in the Supreme Court or in the High Court. So that power was taken away, so that if we want to pay any legal bills, now my bill goes to GAD, GAD sends it to law, law sends it to finance, and only then it gets cleared. So now it's more than a year. I think my standing councils have not been paid even 1 paisa. And on the other hand, they are incurring expenditures because they have to file for wakalats and things like that. So it's a sorry state of affairs. I was asked to, and the third thing is, after each stage, those who have stakes in getting the notification cancelled, they file. The minute the preliminary examination is over, I have failed it, so let me try through some means to get the recruitment notification cancelled or at least stayed. So coaching centers is one stakeholder group, because every time a notification is cancelled, it's 1 more month of coaching and 2 more months of coaching, and I only call them bakras. The poor fellows, they pay through their nose for all these courses. And the second stake group is the contract employees. So they know that if a recruitment notification goes through and regular employees come in, their jobs are at stake. So I've had in AP, before my time, 2 notifications for assistant professors and lecturers in universities and colleges. They have been cancelled on some ground or the other. You can always find some ground or the other. And so now all the universities and they don't have enough assistant professors. I don't have enough lecturers who can come and correct my Group 1 answer scripts. Massive vacancies, but the recruitments are not able to go through because the contract employees, they try some means to get it cancelled. And the new technique that we have found now is that crowdfunding is happening. The failed candidates, they are on the social media, so they're collecting money to pay the lawyers, and it's huge money. It's not small amounts of money. Like after my Group 2 exam is done, there's a whole lot of groups saying that please pay something, we'll employ a lawyer, he will take it right up to Supreme Court. So the crowdfunding for paying legal expenses is going on. So we need to recognize these various stakeholders who are interested in getting the notifications cancelled or delayed. Actually, I was asked to speak about the case study. That case study is actually a reason why we went up to Supreme Court. It's a simple issue actually. There's a GO which says for passing, OCs 40%, BCs 35%, SC/ST 30%. Now the way we interpreted it is that a candidate needs to get 40% marks to be eligible for a OC vacancy, that is an open competition vacancy. So if there is nobody who got 40%, we would carry forward that OC vacancy to the next recruitment. Now, what happened was in a particular recruitment, there was nobody who got 40%. So a BC candidate who got 35%, she challenged it saying that 40% is for other communities and not for open competition. So I am eligible for that OC vacancy. Now single judge agreed with us and said, no, 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 you must get 40% to be eligible for the OC vacancy. But then the division bench of High Court, it said the 40% is for the category and not for the post. So you give her the job. So we went to Supreme Court, and in Supreme Court also we filed a review saying that it will create a mess, because earlier we have carried forward such vacancies. But then they did not agree. So we went back and we had to implement it. And now we are modifying our GO and our recruitment notifications. We are saying very specifically that if you want to access an open competition vacancy, you need to get 40%, because the OC, it can mean either open competition or it can mean other communities. So we did a little bit of modification there. Amirji, I still have time, or? I still have 2 minutes. Another, since we are in Nalsar, I will talk about another case which we lost. Now there's a post, Assistant Commissioner Endowments. A lot of temple lands get occupied, kabja. So they face a lot of court cases. So for that particular post, they wanted advocate with 3 years experience in the High Court. That was the service rule. Now advocates in High Court earn good money. I think nobody was interested in this particular job. So we didn't get many people, we didn't get any people who had practiced in the High Court for 3 years. And nobody got selected. So one person who had a lesser time period, she went to High Court. And the High Court held that advocate practicing in High Court means advocate practicing in High Court and in any of the courts subordinate to it. And now, I mean, every court in Andhra Pradesh is subordinate to the High Court. That means you practice anywhere, you're eligible. Now, who decides whether the person has practiced or not? It is dependent on the Bar Association ka certificate. Now, whether the Bar Association has really seen that candidate practicing, actually this is something which you also need to work on, because we are recruiting a whole lot of prosecutors, especially term prosecutors, and their service condition is 3 years of practice in, and a lot of fake certificates are floating through. So maybe you need to work out a system on at least on a monthly basis or a 6 months basis. You need to have which are the advocates who are actually practicing and who actually have practice in either the courts or the high courts. So now the department is going back and changing the service rule. It says advocates with 3 years of practice only in the High Court of AP. So precision in language is probably very, very important. We had another recruitment notification for deputy education officers. Now they said BA, BEd, MA, post-graduation, everything. Once we read through the whole thing, we found that MA education is not eligible for a post of deputy education officer. Then it involved a lot of correspondence up and down and said, how can you say MA education is not eligible and a BA economics is eligible, BA psychology is eligible. So the equivalency of degrees is again a major problem. Another interesting case I will quote, meritorious sports person. Somyajulu Gari judgment. Who is a meritorious sports person? The GO had sort of description. And in the annexure, they said for Group 1 services, he should have played at the national level or university level. Now the judge looked at it and said, the dog should wag the tail should not wag the dog. So you said nothing about Group 1 or the qualification in the substance of the GO, you've put it in the annexure. So we still call it a kukkatoka judgment, a dog tail judgment, and it's still in force, so we had to change the GO and make a lot of modifications. If you have certain conditions, you want to define a meritorious sportsman, you have to define it in the main body of the order and not in the annexure. The other problem is fitness. Yes. We have time for the next 2 days, so thank you for giving a patient listening to this. Thank you.
Thank you, madam, for your remarks. Many of them are very relevant for all the PSCs. So, now we'll start with our presentation. The formal presentation, I'll run through it. Be around 15-20 minutes, Samirji. So, this one. So I'll not go into the minor detail of the case, which is anyway available in the presentation. It will be part of their official listing, so you can go through it. Yeah. The next one. Yeah. So this examination, particular examination, attracted a lot of attention of the students, coaching institutions, local teachers, social media, even political parties also. Mainly because the number of vacancies is very high. Normally the vacancies used to be in the range of around 500 to 600, but last year it was 2035. So people thought that it's a golden opportunity for them to get through in the class 1 and 2 examination in Bihar. For last 4 or 5 years, our recruitment is really very regular. Every year we have this civil service exam, mostly in the month of July and August and September. Last year it was held in December. This year we are organizing it in September. So about 5 lakh candidates applied for this, and in spite of the huge number of applications, we decided to have single shift, single day examination. Why I am mentioning this? Initially we had thought that if the number of applications are large enough to organize this into 2 shifts, we will go for a 2 shift examination with normalization applied for the result preparation. Now this also has a background. About 3-4 months prior to the advertisement, a huge agitation has taken place in UP on this very issue of normalization. And because of the large agitation, the UP PSC had to abandon the idea of applying the normalization. They said we will have single shift examination for the civil service examination prelim. As soon as we conducted the examination on 13th, and even prior to that also, many rumors had started spreading, mainly about normalization. They thought that because we had mentioned in the advertisement that our examination can be held in multi-shift days, student interpreted that commission will go for normalization anyway. This is an excuse for them, and in spite of agitation in UP, the Bihar Public Service Commission has determined that they will go for the normalization. This is what they interpreted. And of course, the coaching institutions, local coaching institutions, some celebrated gurus, teacher, and social media also fueled this rumor. They in fact helped spreading the rumor. They were leading the agitation that they did in front of the commission's office. They provided them financial support, they provided them the logistical support, even leadership also. Couple of teachers who were come from all the way from Delhi, they were arrested on the day of the agitation. So in spite of commission clarifying the factual position, some of the leaders of political parties and the influence and coaching institutes, mafias, gurus made baseless allegation about normalization on media and social media platform for their, of course, political and selfish interests. The important thing that we need to consider is that this is an election year in Bihar. So assembly election are going to be held in October and November. So all the political parties, especially the one like headed by Mr. Prashant Kishore, they are looking for some fertile ground to, expand their base. And they saw this as an excellent opportunity to influence the youngsters, students, and all the candidates. They thought that they are spread all over, and the number of applications being almost 5 lakh, they thought they can influence a large number of youth there. Apart from normalization, they also made demand for extension of last date. They also made demand for extending the date of examination and many other things on different grounds. But these were small issues. Yes, next one, can you help me? Yeah. Now on date of examination, that is 13th of December, we had around 912 centers all over Bihar. In all centers, except one center in Patna, the Bapu Pariksha Parisar, the examination was completely normal and peaceful. This one particular center, Bapu Pariksha Parisar in Bihar, is a unique center. It has a capacity of around 25,000 students. The government of Bihar few years ago decided that they will have large examination centers to be used by different government agencies for the examination, mainly for class 12, 10 examination and also for the competitive examination. This particular center is in Patna with 25,000 capacity, and there are another 9 centers in different divisional headquarters with a capacity of 5,000 students. On this particular center, we had allocated 12,012 students in one center, and Commission had used this center for the very first time. Commission had never used this center earlier. Considering the large number of applicants, we thought we should use it, and that's why we used that center for the very first time. On some pretext on that day, on delay of distribution of question paper, some students started agitating. They created ruckus, they created disturbances, and in one particular hall, the student in the front row, they snatched one envelope from the invigilators. And taking that out, they went to other classes also and spread the rumor that the question paper has been leaked. They also instigated other students to join in the protest. We have video showing that these agitating students went to some other room, entered from the one entrance, and started, snatching answer sheet of the question of the paper. Students were giving peacefully. That was about an hour after the starting of the examination, because all examination center had the CCTV cameras also. So we have this with us. Basically, they stopped large number of students who were peacefully giving exam from appearing in the examination, from writing the examination. They disturbed the examination. They vitiated the process of the examination in 1 or 2 rooms, 3 rooms. After that, they came out in the corridor, they went to the complex, and also over the fence, over the boundary wall, and handed over that question paper that they had looted from the invigilator to their accomplice who were standing outside the boundary wall, who took the photograph. We have video of these also, taken by some social media or some news agency. They are taking the photograph of that at around 12:45 or so, and at around 6 minutes past 1, we get first information that the paper has gone viral. So they sent that very question paper, which was looted from that center, to one of the news agency. So immediately after this, because many people were interested to postpone this examination, so the mafias, the student leaders, and the teachers, they started protesting, alleging that the question paper was viral on social media. They started demanding cancellation of the examination at all centers, not only on this center. By 3 o'clock, the exam was between 12 noon to 2 o'clock, the 2-hour exam. Around 3:34, we got messages from all the district magistrates that the exam in their district was peaceful in all other 911 centers, except this very center. So during the course of exam only, I had requested DM to proceed to the center. He, along with SSP, went there. He took the situation in his control, allowed the students who were peacefully appearing to continue their examination. Almost half of the students out of 12,000, around 5,500 students peacefully gave the exam on that center also. And they submitted their answer sheets, OMR sheets. Considering 2/3 students who actually appeared in the examination, out of 12,000 students, we are expecting around 8,000 students to participate. But finally, only 5,500 gave the OMR sheets, meaning thereby about 2,500 students were disturbed from giving the examination or voluntarily, started protesting in this line. Leader of some of the political parties also later started supporting them. In the background, I told you why they supported this protest. Now, Commission's response. So see, on that day, Commission has only few CCTV footage and report and clips of some social media. Also, we had asked DM to submit a report. He gave an oral report to me, and also later on written report also. We sent a team from the Commission's office to this center and see what had actually happened. So on the basis of all these things, the Commission decided to conduct re-examination only at one center, that is Bapu Pariksha Parisar. Not because it was disturbed, but because we had proof clearly proving that many of the students were stopped from giving the examination, though they wanted to give. For no fault of theirs, they were obstructed from giving the examination. So that was the very reason why I decided that we will have re-examination on the center. Apart from that, we had this proof also, students snatching the question paper and going out and viral, making it viral. From all other center, we gave a peaceful report, as I told earlier. The agitators, with full support of local coaching mafias, opposed the Commission decision. From the very first day, they wanted the exam to be postponed. They also wanted that we extend the date. On this day, they said, no, we don't want re-exam on this center, we re-exam on all other centers. We said, give any proof. There was no complaint also from the student. We said, you give any proof and we'll consider it. We waited for 3 days. The exam was on 13th of December. The full commission took this decision on 16th of December. By that time, no public media, social media, or any of the candidate had submitted any proof about anything untoward incidents in any of the center. They also started making baseless allegations, large number of allegations, they started making without, of course, without any proof. And in spite of the tremendous pressure on the commission, we stood our ground and we said we have nothing on record which warrant re-examination in all the centers. So why we should punish roughly 4,70,000 students for the fault of this, a few, maybe a dozen or so students. By the way, later on we identified about 15 students, around 40-45 students. We issued so-called notices to them. Out of 13, we debarred them for 5 years, 3 years, like that. Meanwhile, during all this process, the agitators started spreading rumors. They continued their protest unabated. They started organizing dharna, Patna Jam, Road Roko, Bihar Band, Bhuk Hartal, like that. They kept this issue alive because the local popular coaching institutions were interested. They kept this issue alive. Now legal battle. So we knew that this will be challenged in the court of law. So the commission's proceeding of 16th of December, we had given a detailed reasoning why we went to this, why we took this decision. That this decision had two important aspects which will be challenged all through. One, the examination was to be conducted, re-examination was conducted on all the centers. Why you did not consider that aspect? Number one. Number two, if you go for limited examination at one center, will you have a new question paper? And if so, whether you go for normalization or not. So the demand which they were opposing, they now started demanding that if you go for a new question paper, you go for a normalization also. But commission had 3 different incidences of BPSC examination in past 4-5 years, in which at 1 or 2 center the re-examination was held, and we took the re-examination with new question paper and without going into normalization process. We said no, because it is a forced re-examination, we cannot have a normalization because the sample size is totally different. One is only 12,000, another is another is say about 3,70,000. So all these issues they started. In addition to that, they started raising this. But these two are the crux. These two issues were very important. We knew that this will be a challenge in the court of law. The commission gave a detailed reasoning on 16 December itself, in the proceeding itself, that why we took these two important decisions. To stall the examination process, they demanded stay order on the re-examination also. They also started allegation against the commission in the High Court. They started organizing dharna a day before the hearing on in High Court to pressurize High Court also. They will call large number of students in Patna to pressurize the High Court. The agitators with logistic and this I told you. In routine way, they spread the wildest of the rumor and falsehood through exams, daily updates on social media. They started giving bulletins every day. Even some students also who were petitioners, they started giving that. They kept up pressure on the commission. Meanwhile, pending final order of the High Court, the commission on 19th of February declared the schedule of the main examination to be held during 25th to 30th of April. So we not only declare the result of the prelim exam with new question paper and without normalization, which with the approval of the High Court, and also declared this. They wanted to stay there, these as well, but the High Court declined. More than 21,000 students appeared in the main written examination held during April. And we have started evaluating the answer sheet also. On 23rd May we have started. Meanwhile, Finally, High Court heard all the petition on 18th and 19th of March and passed a detailed order rejecting all the demands of the petitioner and dismissing all the petition, including the PIL. So these are important observations of the judgment. The High Court has made certain observations which will be very important and relevant for you. As Commission had apprehended, these two issues were very important for the High Court also, and they agreed with our reasoning that there was no need for a new question paper, no need for a normalization even if a new question paper was used. So now with 12,000 students, you taking new examination for 12,000, so it is not one or two center, it's 12,000 students. And if you held examination with a new question paper and if you don't apply normalization, I think many of these PSC need not reorganize re-examination for all the center. That was a very important takeaway for us. High Court also said many things like there was no proof, there was no need of any proof for any large-scale use of unfair means resulting into vitiation of the exam process. Due to strict frisking and installation of jammers, even if question booklet was circulated on social media after about an hour or so, no examinee could have been possibly benefited as they were all sitting in a sanitized examination halls without access to internet connectivity or electronic gadgets. Mere posts on Facebook, X, WhatsApp, etc. about mass scale malpractices or paper leaks are not sufficient evidence. This High Court has very clearly mentioned all these things. This is, I think, verbatim we are quoting. Only out of the nefarious design of the coaching centers to have more enlistment for profit, instead of students being explained the concept of normalization, they were supported in their agitation even before the exam started. This was not a responsible act. This is what High Court said. A High Court also directed the Commission to set up a high-level committee of experts to review the security measures and overall management of the examination. Of course, the kind of interest it has generated, we knew that this will be a challenge in the Supreme Court as well. And they had eminent lawyers, a battery of lawyers with them. More than 20 lawyers appeared for them. And the final battle was at Supreme Court level on 23rd of April. Supreme Court at hearing said itself dismissed all the petitions. They did not pass a detailed order, but they agreed with the reasoning of the High Court order. The same important takeaways I have listed here, which you can go through later on. For the shortage of time, I will not read through. But High Court had given 31 or 32 specific issues. Out of that, important issues I have listed here. So this was all from my side. Thank you for this.
So we have 20 minutes for the floor.
This is what we had agreed to. Yeah, sure. Any question about any of the issues made by the panelists or on the presentation, of course?
I think if there is no other points to discuss, I think Madam had to cut short the discussion, so she can add something.
Sure, nobody else?
Regarding what Madam said, see, when the governments change, the advocates also change. So, in Tamil Nadu, the system we follow is it's inevitable. See, when the governments change, they are political appointments, so the advocates sometimes get changed. So, but Tamil Nadu system is the existing advocates, even though they may belong to previous political party or something, they are allowed to continue till the new set of office bearers take charge. Because it's not only TNPSC cases, there are thousands of other cases for government which are urgent and critical also. So the old system continues till the new advocates take charge and come into picture.
They are expected to, but not all advocates are that committed, and especially if they are not paid and the pay is not coming through and they have to incur costs. So when I remember one ACF recruitment, where the case came up onto the court, there was no representation from APPSC. So that particular batch had to wait nearly 7 months, and then they went to Supreme Court, got orders from there to the High Court saying that please finish the hearings fast, and only then the case got resolved. So the advocates also, they lose interest, and there is no stake in sort of keeping track of when the case is coming up for trial and appearing there at that point of time. That if the transition is as fast as possible, it is good.
In our case, we have our own panel of advocates, commissions on panel of advocates.
Yeah, we are lucky. I mean, Bihar also, we have our own panel of advocates, about 20. We can add or remove any panelist.
Also has a panel of advocates which we appoint, of course in consultation with AG informally or formally, and we can also appoint private advocates at our own convenience depending on need-to-need basis.
Absolutely. We have this freedom.
The advocate on record who was informally engaged by the previous government has not been paid for the past 2 years. Supreme Court mein. She keeps asking, ma'am, please get my bills.
But they are paid
clear.
by government, or the commission pays them?
The commission was supposed to pay them, but since the head of account was removed, we are no longer in a position to pay them. And then when we send it to government, government says, no, you should have appointed the government AOR. You have no powers to use her services. So it's still going up and down.
Actually, payment to advocates is a very common problem for all departments, because they sometimes, even for the smallest advocate, they may charge 350 rupees, 250 rupees per case and all, sometimes in different kind of cases. So it becomes difficult to process these bills and other things. And every time, as madam said, the order goes up to HOD or somebody, then they have to verify whether the case has been appeared and whether the name of the advocate appears in that particular cause list or something. So all those verifications take a lot of time. So then finally, when the governments change, it even meets a bigger problem for the advocates, because the interest is lost. They lose their office, so nobody to follow up on their behalf. So it became a very big crisis in Tamil Nadu. The old advocates, they put cases before High Court, and High Court took this very seriously, and because some of them are not paid even for 10 years, 15 years, just by oversight. It's not because of lack of money or budget, but paperwork was not done properly. Sometimes records are not there. Where is the proof that you appeared 10 years back in some case? So then High Court got really very annoyed in the good sense. So and they said hereafter find a new system, so that these people are paid then and there without waiting for all these hassles of bringing it up to the highest level in government and all. And they gave about 6 months time for us to settle all the pending bills, whichever was presented before them by the advocate. So we made a special drive, and then government has delegated it to the bottommost level now. So even AG is authorized now. AG has become a HOD, so they have authorized AG to pay the bills then and there for most of the cases. So it doesn't even come to our administrative departments.
Okay. See, we have a different thing, See, and we have the freedom to do I belong to Kerala Public Service Commission, See, what the issue raised by the madam, we do not have any such problem there. So we have the freedom to appoint the legal retainer. We call it as a legal retainer, and the government never interferes in that. So we have the freedom to do that. Even if the government changes, even if the commission, the whole commission is also changed, there is no problem. We have the freedom to retain the legal retainer there, and we have the freedom to that, and the government won't interfere in the budget matters, isn't it? So we have the freedom to do that. So in that matter, for us, we are so blessed in that way.
But it works the other way around. So the previous government paid about 2-3 crores to a particular advocate for one particular case. So that sort of misuse is also there.
Issue regarding changing of AG and all.
And now what we are saying is, whatever we are paying the proposal that I have sent to government, which is yet to be approved, is that the standing council's pay should include all his expenses. His pay includes his expenses, so that he doesn't have to bill for every 5,000, 10,000, and then it goes through. So hopefully that will come through.
So, madam, what we do is, there is not, his payment is fixed, and it is fixed by the commission itself. And for every case, it's not that way. There is a fixed payment is there, and for other official office purposes and other things, he can claim, the actual bills will be sent to the commission, and we pay on the basis of that.
I think maybe the payment of advocates, it's better to have a consultative process of the state government advocate general, and also what are the best practices UPSC. Because generally in the educational universities we will look at UGC, how they have a legal retainer system, and then all of us we will look at maybe in that process UPSC state advocate general's participation will help. If it is necessary, a comprehensive best practices can be taken from the Ministry of Law and Justice. There are also overall, so I think that will create a uniformity. Of course, it depends upon the experience of the advocate, nature of the case, several others will be there. So when you are engaging a senior advocate, even for appearance before High Court and Supreme Court, is huge. So that classification of disputes and the lawyers and best practices, UPSC may be a better, whatever they have, that can be discussed, but participation of the Advocate General of the state would be better.
And they also charge on the basis of the number of WPs.
Number of
like
WPs.
On one issue,
correct.
you might have 10, 20 WPs.
20.
And if you're charging on the basis of WPs, the bill goes huge.
That's a better rather than the number of cases.
Yes. Honorable Vice Chancellors were referring to Section 89 of CPC, which deals with
Yes.
ADR,
Yes.
alternate dispute resolution. But whether it is applicable to selection process, it is not directly applicable to the selection process. What can be done?
Okay.
The PSC can constitute appellate authority, which can hear the appeals of the candidates regarding rejection of their candidature.
Yeah, I think
What your
internal grievance redressal mechanism is the
Yes.
best one. But for that, the trend of increasing is use of compromise, means call both the parties. Section 89 has created a new jurisprudence where everybody is following. So I think you are right. It may not be directly applicable to that, but it depends upon the complex nature of disputes. But the best is you have your own tribunal system. First is simple grievance redressal mechanism.
that is in the
That's the, yeah.
PSC itself.
Yeah, within the PSC.
Yes,
and
yes.
then if there's any complex nature, you can look at either outside the Public Service Commission or engaging. Now with the online dispute resolution mechanism, I think that's a way which is available, the new future path of justice delivery.
So my question is the same, that mediation is not applicable in service matters, because as and when matters are listed before Lok Adalat, the panel right away says that service matters cannot be listed for Lok Adalat. So in Goa also we face the same issue, that it is not applicable in service matters.
No, I think this Mediation Act, new Mediation Act has a table which can be resolved, which cannot be resolved. I think everything can be resolved. But I think somewhere, even the government, they have not mentioned exactly service disputes. Government-related disputes is mentioned. But I think nothing takes away mediation in future. In fact, 2022, in fact, the Supreme Court said even you can use even the criminal cases, criminal law cases, probation, compounding, and plea bargaining, everything has to be used. So I think they have not removed the scope, but scope is still there.
But
They are just now three.
Always PSC has to frame those under the rules.